we go. So that's going to record. And just before I get going with the start of the case law update, you'll know that here at King's, we are all very friendly and we will adopt a very flexible approach. So here's our contact details. And when we say contact us if you need to ask any queries or any questions or just discuss the case informally, then we do really mean it. And those are our respective email addresses. There's also the email address of Louise Barnes, who has primary conduct of clerking the Wills Trust and Probate team. And also we've got our Twitter accounts, and certainly Sarah and I do our best to keep everybody up to date with cases, so by all means do give us a follow. So part one of the Wills Trust and Probate case law update, and we've set it across two parts because, as you know, this area is so broad and we want to satisfy as many of you who may be doing contentious and also non-contentious areas. So we felt that to do that justice, we're going to split it in two parts. So the next instalment is going to be in 2 weeks. But today, as I say, it's part one. First, we're going to deal with what I've termed as administration of estates. And then Sarah's going to take over with some 1975 Act cases. There's certainly been a flurry of those on cost decisions in recent weeks. And then last but not least, we've got Richard, who's going to deal with proprietary estoppel. And then in the next instalment, we have got will validity, save for capacity, because that's going to be dealt with by Nigel Clayton, because certainly that's a topic that I think deserves its own attention in its own right. And then we're going to have a topic on personal representatives. So I'm going to pick up there and deal with applications to remove fiduciary duties, things of that nature. So on to administration of estates. And before I get going with the 3 cases that I've picked to talk about, what I'm going to say is that certainly my approach with the case law update is not to give you every aspect of the decision. It's really to tell you some of the facts, tell you what are the important, from my view, aspects of the case. And so if it ever crops up in practice, then we've flagged it up for you. So then you can go and read it yourself in much greater detail. And the cases I've picked deal with, I think, some quite interesting facets of administration of estates. Not ones that perhaps come across your desk every single day, but they will do in practice at some point. And so it's useful to just have a case in mind that you can just use as a point of reference if you do have a case that deals with these particular aspects. So the first case is Amos and Mancini, and some of you who follow me on LinkedIn will see that I posted about this a couple of days ago. It's quite an interesting forfeiture case. And just to go over some of the facts that are relevant. So it concerned Mr. and Mrs. Amos, and the deceased was Mr. Amos. He died in a road traffic accident. And the circumstances of his death are important for this case because he and his wife had been travelling to the funeral of his sister. They had got lost and they had been travelling for a long time, and Mrs. Amos took over the driving. What then very sadly happened was she collided with a car in front of her vehicle at a roundabout, and that then caused further collisions. Very sadly, as a result of that, Mr. Amos passed away because he sustained fatal injuries. And so Mrs. Amos was then charged, and she pleaded guilty to causing her husband's death by careless driving under Section 2B of the Road Traffic Act. To her credit, as the judge said, she pleaded guilty at the earliest opportunity. And there is reference to the sentencing within the case. And it was said that it was a lapse in concentration, but it was a significant one. And ultimately, I think she received a suspended sentence. Now, the will is important for this case because as a result of Mr. Amos's death, the forfeiture rule, which I'll detail in a moment, certainly prima facie applied, because by his will, he had, as often happens with husband and wife, left his residuary estate to his wife. He had the usual substitution clauses that you might have, so she predeceased him. He made certain legacies to his own daughter by a previous marriage, and then he left his residuary estate between Mrs. Amos's son from a previous marriage and also his own granddaughter. So those were the terms of the will. And quite rightly, those involved in the case considered the principle of forfeiture. Now, for those of you who aren't familiar with that, it's a common law concept, but it's set down in the Forfeiture Act 1982. And Section 1 of that Act sets out that it's a rule of public policy which in certain circumstances precludes a person who has unlawfully killed another from acquiring a benefit in consequence of the killing. And that's really indicative of a wider common law concept that one can't benefit from their own criminal conduct. So the issue here was the claim made under the Forfeiture Act. And there are two key issues, which I'll go into in a moment. But essentially, Mrs. Amos's claim was first to seek a declaration from the court on whether the forfeiture rule applied to her. Because if it did, prima facie, it meant that she wasn't entitled to the gift of the residuary estate under her husband's will. But not only that, they owned under a joint tenancy their marital home. And if the rule applied, she would not be entitled to the rule, to take advantage of the rule of joint survivorship. So that was the first point for her. The second was that if that rule did apply to her, could she seek modification of it under Section 2 of the Forfeiture Act? Because there is effectively a discretion in the Act that if the rule does apply, a court can depart from it in certain circumstances. So the first issue that was raised was, did the rule apply to the offence of causing death by careless driving? And the reason I think this was an issue is because some of the legal texts had set out a view that this forfeiture rule doesn't actually apply to careless driving. So the court was tasked with determining that. And that's really a summary there for you of the view of the High Court judge. He recognised that there wasn't a direct authority on the question of whether this particular offence was caught by the rule, but he considered the Court of Appeal case of Dunbar and Plant, and the principle you can discern from that is that the rule applies to all cases of manslaughter. Now, Dunbar was decided prior to the creation of this offence that Mrs. Amos was convicted of. But the court recognised that even though that was the case, since Dunbar, the courts have consistently applied the principle set out in there, that the rule applies to all cases of manslaughter. And what the judge said here was that it would lead to an illogical outcome and an unjust outcome to apply the forfeiture rule to all cases of manslaughter, but not to apply it to cases of causing death by dangerous driving, by careless driving. So on the first issue, the court found that the rule of forfeiture did apply. And the second issue was, well, should the court use its power to modify that rule, to effectively depart from it? And I've set out there for you Section 2 of the Act, which sets out when a court can modify the rule. And it can only do so if it is satisfied that the justice of the case requires it. And when a court considers that, it has to take into account certain factors, including the conduct of both the offender and the deceased. So culpability is a key material factor for the court to consider. But then there's the catch-all provision of all other material circumstances. So there's by no means an exhaustive list of factors. One aspect I thought would be helpful for those of you who aren't particularly familiar with forfeiture cases to bring to your attention is just Section 2.3 of the Act, which sets out effectively a limitation period that you need to be aware of. And it's that any claim for a declaration or relief under this Act must be brought within 3 months of the conviction. And so the outcome in this particular case was that on the circumstances that the court was faced with, that Mrs. Amos was entitled for the rule of forfeiture to be modified. And the court held that it would be unjust for the rule to apply so as to deprive Mrs. Amos of her husband's share in the marital home and the gift of the residuary estate under the will. And the court set out a number of factors that it felt were material. For example, that she pleaded guilty at the first opportunity, and the circumstances of the particular offence. Not only that, the court was particularly mindful of that clearly these two wanted their respective half to inherit their estate. At the end there, I've said that the court placed little, if any, weight on the statement that was made by Mr. Amos's daughter. She had effectively served a statement, or a purported statement, because it wasn't signed by a statement of truth, suggesting that Mr. Amos had indicated to her that he wanted to change his will prior to this incident happening, but the court placed no weight on that. And here's a key reason for the court's decision to modify the rule of forfeiture. It said that the result of applying the rule strictly would be all out of proportion to her culpability in the offence. So I think what you can take from this is that, as with many cases in this area, they are always fact specific. You can glean certain principles from the cases, but by no means is a court going to apply certain decisions because of facts in other cases. And I think the key, or the magnetic factor in the court's decision here, was about the level of culpability. So the second case, and I'm going to whiz through these, I'm so conscious of the time, is Johnson Persons Unknown. This is a case under the Presumption of Death Act 2013. The deceased was suffering from dementia, and he had gone to attend a dance class. It seemed to me, from reading the judgment, was suffering from acute episode of confusion and disorientation, because he called up his spouse, his civil partner, saying that he couldn't remember where he'd left his car. He was then never seen again, very sadly. There was some evidence that he'd been on a train from Birmingham to London, because after he went missing, a letter arrived for him with a fixed penalty notice because he was unable to pay the train ticket. But very sadly, despite a police search and a public neighbourhood search, the deceased was never found. Now, he had prepared a will in 1996, but subsequent to that, he married or entered into a civil partnership, I should say. And of course, the effect of that was to revoke that existing will. So essentially, when he passed away, he died intestate and he had no children. Now, it became slightly complicated because after the deceased went missing in 2011, his civil partner was advised to sever the joint tenancy on their property that they both lived in. And so he did that in 2016. Then in 2017, his civil partner also died. He left a will leaving his estate to other individuals. That created some real uncertainty about the manner in which the deceased estate should be distributed. And as a result of that, there was cause to bring an application before the court under the Presumption of Death Act 2013. And it was the deceased brothers that made this application, seeking a declaration that he had passed away and when he had passed away. Now, the reason there was some difficulty for the court here was that when it makes a declaration under the 2013 Act, Section 2.2 requires the court to make a finding as to the date and time of the missing person's death. But here there was some real difficulty in doing that, because whilst there was suspicion, I think is the highest it can be put, the deceased had probably died soon after he went missing because of the particular state that he was in, there certainly wasn't sufficient evidence to make that finding on the balance of probability. But for reasons of establishing how the deceased's estate was to be distributed, but also his partner's estate, it was necessary to make that finding. And so the reason it was in this particular case to necessary to make that finding is because if the deceased had died prior to the severance of the joint tenancy, then his civil partner was entitled, of course, to the entire beneficial interest in the property on his partner's death. If it, however, happened after the severance of the joint tenancy, but before his partner's death, then his partner would inherit his estate on intestacy. But if he died after his civil partner's death, then the deceased brothers would be entitled to his estate under intestacy. So you can see how here it was so important because it would have a different outcome. And it's particularly important in cases I've seen because of pension payments. Because it may be that if the date is much later, the date of death is much later than the executor actually realised, then there can be a liability to repay those ongoing pension payments. So the court applies its mind to section 2.3, which says that if a court is satisfied that the missing person has died, which the court was, but they don't know or are uncertain about the moment during the period that the missing person died, so effectively they can't make a finding about when the deceased died, the finding must be that the missing person is presumed to have died at the end of that period. Now the issue here is, well, what is that period? Because the Act doesn't help us with that. And last year, Chief Master Marsh, in the case of Re AB, referred to that term as a troubling provision. And what Chief Master Marsh found is that that period, or the end of that period, is the date of the hearing when the declaration under the 2013 Act is made. And the court in this particular case agreed with Chief Master Marsh's logic and applied it here. So what did that mean in practice? Well, it meant this, that the declaration about his death was made at 11:30 a.m. on the 5th of February 2020. And remember, the deceased went missing in 2011. And so that was fixed as the date of death and had the consequence that his brothers inherited his estate. And understandably, the judge was troubled by that consequence. And he said that I do not regard this as according with common sense, but his decision accorded with what the law required of him. So it's a useful aspect to bear in mind if you have cases of a similar nature. And the final case is this. I'm not even going to attempt to pronounce the first name because my Lithuanian is not too great, I must confess. But it's an interesting case because it concerns a dispute between two daughters about how their mother's body was going to be disposed of. One daughter said it should be cremated and that her ashes should be scattered in the UK. The deceased was Lithuanian, but had been living in the UK for a number of years and was very much settled here. Her other daughter, R, accepted she should be cremated, but she said that her ashes should be taken to Lithuania and scattered there in a particular graveyard. And daughter R said that those were the wishes of her mother. Now, important points to bear in mind is that the deceased's will appointed only one daughter as her executrix, and she was the sole beneficiary. Now, a bit of protracted history prior to it being finally determined, because there were a number of injunctions that were sought by the other daughter. And essentially what the other daughter did was what seemed to me fraudulently take out letters of administration, knowing that there was a will. But she was able to do that. And essentially she got an injunction stopping her sister from releasing her mother's body, from the coroner releasing her mother's body to her sister. So it came to a final hearing before a High Court judge to determine who should be responsible for disposing of the body. Now, for those of you who haven't dealt with a case of this nature, this is a useful case to read because it goes through all the authorities, and there are quite a number on this area. But just by way of reminder, the starting point is that there is no right of ownership in a body, but generally the duty to arrange the disposal of a body rests primarily with the personal representatives, but a court does have the power to depart from that. And the personal representative's view, if there's no dispute about the will often be given a high priority. So here what we had was a dispute about the validity of the will and a divergence of view amongst the nearest relatives about what should happen to the body. So the court considered what powers it had to deal with this. The first power that it can have in certain circumstances is under section 116 of the Senior Courts Act. You will know that allows a court to pass over someone entitled to take out a grant. The court found it wasn't applicable here because a grant had already been taken out, albeit under questionable circumstances. But the court does have an inherent jurisdiction to supervise the administration of estates. And it has been said by the Court of Appeal in the Ian Grundy case in, I think, 2017, that the court does have that jurisdiction to make decisions about who should deal with the disposal of a body and how it should be disposed of. So in this case, what the court did was it ordered the coroner to release the mother's body to her daughter R, who was the executor under the disputed will. And the court took into account a number of factors. One of those is that even though the other daughter was claiming there was a dispute about the validity of the will, the court, whilst it wasn't able to make a determination about that, and it wasn't placed to do that, considered that there really wasn't that much in it. So the reality was that R, in due course, would have the standing to act as the executor. One key factor, and I think this is usually the guiding or magnetic factor, is what evidence is there of the wishes of the deceased. Now, a deceased's wishes about their funeral or their burial, they're not enforceable against a personal representative, but they are certainly persuasive. And the court here found that the evidence lended itself to the conclusion that the deceased wanted her remains to be scattered in Lithuania. There are other factors, for example, that there was a strained relationship between the mother and the daughter Elle. But the most important consideration in a case like this is disposing of the body respectfully, decently, but importantly without delay. And that's an important fact to remember, because if you have on the sidelines, a dispute about the validity of the will, we can't wait to dispose of the body until the conclusion of that case. So a court has to make a decision before that has been determined. Now, over to Sarah.
I hope I've got that right and you can all now see me. And I will hopefully share my screen. Right. If I can begin by mirroring what Fay has said in terms of two matters, that's both in terms of our approachability as members of King's Chambers. Never be afraid to pick up the phone or send us an email, whether it's about the matters we're talking about today or more generally. We don't expect to know that there is an instruction coming in order to be more than willing to assist in matters. And also to say that I've given details of the 4 cases that I'm going to discuss with you today on the recoverability of CFA uplifts in Inheritance Act claims. But I have given you slightly more detail simply because all 4 cases for me are quite interesting as IPFDA cases in terms of the awards that were given, which obviously in 15 minutes I definitely haven't got time to go into today and goes beyond the scope of today's talk in any event. But I have given you the details there so that if you've got cases that are similar, that I think we're all always looking for IPFDA cases. They are there for you to see. Now, I've begun with an ABBA quote, which may seem a bit odd, but the reason for that is because when I first wrote this speech, this seminar, it was going to stop at the case of Bullock and Denton, the unreported decision of His Honour Judge Gosnell from March. And he begins, the first paragraph, it begins with, "The judges will decide, the likes of me abide, spectators of the show always staying low," a quote from ABBA. But however, since I wrote this original seminar, the decision of Mr. Justice Cohen in Re H has now come down, and actually to some extent answers some of the questions that Bullock and Denton had left. But in other ways opens more of its own. I would imagine most of you will be familiar with Lilliman and Lilliman. But let's look at where we're starting with. So we have, of course, the 2013 provision by which, coming from the Legal Aid, Sentencing and Punishment of Offenders Act, that costs orders cannot include the provision for the payment by one party of all or part of a success fee. But how, if at all, do we balance that with Section 3(1)A of the Inheritance Act, which says that the financial resources and financial needs an applicant has or is likely to have in the foreseeable future must be considered. And if a claimant has entered into a CFA with an uplift, they are likely to have a debt if they recover under the Act for that uplift. And that is a debt and a foreseeable financial need that they have. And so the decision of the courts really have been how to interplay the two. Now, Lilliman itself and the decision of Mr. Justice Briggs, as he then was, is not a CFA uplift case. It is actually about Part 36 consequences. That is a case where there was it's a short marriage, big money case, £6 million estate, but £5 million of it was tied up in shares in the private company that Mr. Lilliman had established and had run. And the concern really that Mr. Justice Briggs had at that point was in relation to whether or not there had been Part 36 offers. The parties correctly had refused or considered it inappropriate to inform him of any negotiations that there had been between the parties. And he was concerned really that there was now a conflict between the IPFDA, in which he considered there was no consideration of costs offers, and those in matrimonial finance proceedings, where of course there is an emphasis on open offers, Calder Bank offers not being allowed, i.e. closed offers, so that the court can consider whether or not those costs, those offers are reasonable or not. In that case, counsel both agreed that there was no alternative but to leave contingent cost liabilities, i.e. Part 36 liabilities, entirely out of the account. And therefore, although he said that that might be unrealistic in the real world, he didn't actually have to go on and consider whether or not that was of issue. We then come forward in time to last year and to the decision of Deputy Master Linwood in Re Clark. This was a case that was predominantly about an inter-vivos gift that had been made by the deceased to his children. It's a case where there is really quite some criticism of the solicitor that was involved in making that gift of land to his children, because at various points there were significant errors in the advice that was given over whether or not his wife would have an entitlement to stay in the property upon his death. So the first thing that the court had to deal with was whether or not the property should come back into his estate. And then there was a claim under the Inheritance Act by the wife in relation to her reasonable financial provision. The defendants in this case, the daughters, weren't in attendance and weren't represented. The claimant herself had virtually no savings, and as you might expect in those circumstances, there was a CFA. The success fee was 100%, and therefore at the time of trial was estimated at almost £200,000. The award that was given was essentially half of the estate, although it wasn't worked out on that basis. It was done on the basis of a capitalised need for nursing home and loss of state benefits. The revision had been granted, and so the home was held on constructive trust for the estate. Now, paragraph 196 is very significant, and certainly for the last year, this has been the approach that us as lawyers have taken, certainly in relation to litigation, which is that the calculation of an award under the Inheritance Act is before costs and has never included an element of costs. It would be contrary to the policy of the CLPA from January 2013, when the amendment was made, that to increase an award, that by considering the costs position, that would increase an award. And that would allow a litigant who is in a CFA to be in a better position on negotiations than somebody who wasn't on a CFA, because back to the old days, the substantial cost burden that would potentially place on the defendant if they were unsuccessful. And finally, the fifth point that was made was that a claimant under an IPFDA shouldn't be in a better position than, say, a personal injury claimant claiming damages. And so, as I say, for the last year, that has been the position. I have to say, in my own experience in alternative dispute resolution and mediation, we have, both as claimant and defendant advocates, used CFA uplifts, as much from the point of view, even if it was accepted that there was no prospect of recoverability at trial, the reality that if you wanted a claimant to settle as a defendant, they had to have the money to do what was necessary, which was to buy off that uplift from their solicitor. And vice versa, a claimant, when you were advising them, if all they were going to get was a life interest, how were they going to pay you? Were you going to either not enforce the CFA uplift against them, or were you going to be in a position that, having secured, say, a property for them, you were now going to have to force them to sell that property in order to deal with the liability to you? We then move forward to March of 2020 of this year, and the unreported decision of His Honour Judge Gosnell in Bullock and Denton. Fay and I both have copies of the judgment, and so if any of you are struggling and want it, please just email us and we'll happily pass that on. This was a case that was a short relationship, and indeed the main issue in this case was not about reasonable financial provision, but was in fact as to whether or not the claimant was a cohabitee, in the sense of a living as husband and wife. The defendants argued, the executors and the brother argued that in fact she had been more of a housekeeper, that there was no relationship between them. The deceased had actually suffered a stroke before their relationship had begun. And it was argued that really she lived with him, she cared for him, although found by His Honour Judge Gosnell that she cared for him badly. But she cared for him in recompense for the fact that he provided her with some small gifts and accommodation. His estate was around 2 million, and you'll see there that she was awarded a life interest in £140,000 plus an outright amount of £6,000 for the legal costs of setting up the trust and the costs of moving, and then a lump sum of £65,000 for a new car, paying off of some debts and white goods. The most important point for us here is she had entered into both a DBA, a damages-based agreement with her previous solicitors, and then a CFA with her new solicitors. His Honour Judge Gosnell ignored completely the damages-based agreement. It was uncertain as to what her liability might be under the CFA, but it was considered by Mr. Justice Cohen in Re H that the lump sum that His Honour Judge Gosnell awarded of £25,000 towards her success fee was probably less than 50% of her liability. Now, what is significant here is that the 5-point test that I took you to in Re Clark was not considered by His Honour Judge Gosnell. So what we don't know is whether he considered and moved away from those factors or simply was unaware of them. He did consider Lilliman, but held that additional liabilities under a CFA were different to Part 36 consequences because the additional liabilities were a debt, and he prayed in aid or used to support that Section 3(5) of the Inheritance Act, where, of course, the relevant date is the date of trial, for the purpose of needs, not death. And therefore, although it was a liability that she'd entered into after death, he found that he could consider it under that provision. And so finally, we have a very, very recent decision, which is that of Inri H. Thankfully, Mr. Justice Cohen was able to consider all three of the previous cases that I've referred you to. In this case, the claimant is an adult child. She had capacity, but did have severe and debilitating mental illness, some of which related from her early 20s when she moved out of home, and the majority of which came from pre- and postnatal depression from 2011 and 2014. The deceased had died in a house fire, and the claimant's mum, his widow, was moved into a care home thereafter. She didn't really participate, and there was real issues over the evidence that was provided on her behalf and large amounts of costs orders. She was present at the hearing, albeit it was a remote hearing, and she was profoundly deaf and couldn't hear what was going on. The first issue the court had to deal with was whether or not to exercise their powers under Section 9, in that the vast majority of the assets that the deceased H had were the matrimonial, his share of the matrimonial property, which of course passed to the wife automatically under the survivorship principles. And it was held that those Section 9 powers should be exercised, and that his half share in their joint assets was around 554,000. The daughter, in effect, claimant, was asking for the entire estate. That is how the submissions would have worked out, particularly once costs had been dealt with. And the request for the CFA uplift was at 72% uplift, which was around £48,000. As I've said, he did consider, Mr. Justice Cohen did consider all three cases, and the award there, you can see I've broken down, was 122,000. So an estate of just over $500,000 and 122,000. Daughter had very much wanted a house. She'd very much wanted a home. However, Mr. Justice Cohen considered that, in fact, whilst that was her priority, the main priority should indeed be her getting well and allowing her to get back some sense of independence so that she could support herself. He also factored in that awarding her a property essentially would remove the entirety of the estate. What he did say in considering Inri Clark was that he was not making a large award as they had done Inri Clark. If you remember, Inri Clark, we had a £700,000 lump sum awarded. And I think the point here was, with 122,000, if 70 odd thousand was potentially going to go in the uplift, it really didn't allow for any elasticity for the claimant. And he held that it wasn't fair to ignore the claimant's liability to her solicitors, and specifically referenced that he was following the same approach that His Honour Judge Gosnell had done in Bullock and Denton. And for me, the significant part, and the part that perhaps will need to be considered on appeal, is this. He said, I recognise that there is a risk of injustice to the estate, in particular if an appropriate Part 36 offer has been made, of which I am necessarily unaware at this stage of proceedings. Of course, that was the same point that was made in Lilliman. In addition, I flag up that I do not know the precise terms of the agreement and what is the definition of success. I don't think there was any real suggestion that this wouldn't be considered a success. I think the point that was being raised there was, if there had been offers that the solicitors had advised not to accept, that might then not result in a success. And I've underlined the next few words. If my award does not bring about the operation of the uplift, I will revisit this element of the award. Now, I find that really quite unusual, that the court is saying that, having made a judgment, having made a decision, then gone on and determined the next stage, which is costs, it is then open to the court to go back and reopen their decision. I find that quite difficult to accept, although I understand and accept the way in which that has been done. That for me is quite different to the decision of His Honour Judge Gosnell. He made a lump sum award, of which it appears he included 25,000 for that, or as a contribution towards whatever the CFA uplift may be. Mr. Justice Cohen did say that he was taking a cautious approach by allowing, and the amount that he allowed was 16,750, which he described as a reasonable CFA markup, which seems to have been, again, a nudge to the solicitors that that is all they should take and that they shouldn't be taking more, or the true amount that they were entitled to under the CFA. But as I say, whilst it appeared, certainly from His Honour Judge Gosnell's decision back in March, that we were going to be looking at a conflict between In re Clarke and his decision in Bullock and Denton, because he'd not considered In re Clarke, I suspect now that with In re H, this conditional approach to the award, which Mr. Justice Cohen appears to have been taken, may in fact be the bigger question for us all going forward. And on that, I think I have to stop sharing now. Hopefully Fay can take back over and pass over to Richard.
Yeah, so next we've got Richard with proprietary estoppel. So over to you.
Thank you very much. I'm sorry for those of you who haven't can see that I haven't got the King's Chambers screen behind me. It came up back to front and I couldn't work out how to turn it the right way round, but I am me, so you can rest assured on that. If I can get my slide up. Can everybody see that now? Good. So I'm going to be talking about proprietary estoppel. For those who were hoping for a clear definition of what that means, there isn't one. As Gardner said, there's no definition of proprietary estoppel that is both comprehensive and uncontroversial, and many attempts at one have been neither. That's not entirely going to deter me. There are two main decisions on proprietary estoppel from the House of Lords. One is in the case of Yeoman's Row Management Limited. Now that was a commercial case where commercial dealings fell down and the parties tried to plug the gap with proprietary estoppel. And in that case, there were a number of issues raised by the court as to why that wasn't appropriate. And the claim failed. Now, what I'm going to be looking at is not so much the commercial cases, but the non-commercial ones, which are generally disputes within families. There was another House of Lords case, which is probably still the leading case, Thorner and Major. But if you take one thing away from what I'm saying this afternoon, if you want the best definition you're going to get and the best summary of the principles of proprietary estoppel, the place to go is the judgment of Lord Justice Lewison and Davis and Davis. He deals with the Thorner and Major issues and all sorts of other issues there. So if you forget everything else, just remember Davis and Davis. Now, there are generally four main points in proprietary estoppel. One is an assurance of sufficient clarity. And the paradigm example, one day, son, this will all be yours. There's then reliance on that assurance. And you'll see here, this is the son at the careers fair. He comes home and he says, well, I'm going to forsake a lucrative career as a property litigator and become a farmer, Dad. Third is detriment as a result of that reliance. And again, most of your clients, I'm taking farming cases as an example this afternoon because so many of the cases are farming cases. They'll tell you that they've worked at least 23 hours a day, at least 8 days a week for the last 40 years, longer at harvest and for no pay, and often even longer in Yorkshire as well. And once you've got through those 3 points, the fourth one, the court decides how to satisfy the equity, exercising a broad but not unfettered judicial discretion. Now, anybody reading that can see how vague that is. and indeed it is vague, and sometimes it's hard to discern principles from the authorities. So they're the 4 main points. Where do the authorities generally arise? Well, some deal with discrete issues, but most of the cases deal with what happens where the claimant falls a bit short in one or more of the first 3 categories. And sometimes that means that they fail altogether, but sometimes the question for the court is, well, how do you deal with that shortfall when you come to the 4th issue and you're determining what the equity is? So just to give examples before I come on to the case law update, leading case of Thorner and Major, you may remember that the representations there were pretty woeful. The only thing that were really identified was that the owner handed the claimant a prudential bonus notice saying that's for my death duties, and pointed out that there was a particular cattle trough that didn't freeze up in winter. Now that was taken by the House of Lords as a clear and unequivocal representation that the claimant would inherit on the death of the farm owner. And the reason for that was because the gap in number 1 of my categories was made good by the reliance and detriment many years working for next to nothing on this farm, which made it clear that that was how he'd understood the representation. So on points 1, 2 and 3, there's something in practice of a points approach where deficiencies in one can make good, can be made good by strong evidence of the others. But other cases where the courts have to determine the position is what happens if the parties fall out long before the owner dies, long before he has to, he might be expected to make good his promise to leave the property. What about the situation where the claimant has received substantial benefit anyway, for instance, been taken into a farming partnership or received other monies, that sort of thing? And still by way of introduction to the cases I'm going to come to, there are hundreds of reported cases or semi-reported cases you can find on Bailey or something like that, but very few of them actually lay down any real principles, and it's dangerous to compare the facts. I gave the example of Thorner and Major and the paucity of the representation there. You'll always find cases that have got better representations than yours, or worse representations than yours, or better reliance than yours, or worse reliance. It's very dangerous to say, well, look at the facts of this case and apply them to mine. So the 3 recent cases that I'm going to talk to you about, one is Honour Judge Mark Rayside in Leeds. That's a decision from March. Second is a decision of the Court of Appeal in Haberfield about this time last year. And the third one is another recent decision, Guest and Guest, in the Court of Appeal. Wills and Sauray, first of all, that dealt with a discrete point, and it's something which has rumbled for years as a point of debate. So there were 2 claimants in that case, but one of them was James. And James agreed with Tony that if James gave Tony his Jeep, then Tony would leave some land to him when he died. And the argument went on behalf of Tony, well, what James is actually trying to do here is to enforce an argument for the sale of an agreement for the sale of land, which is actually unenforceable because of the provisions of Section 2 of the Law Reform Miscellaneous Provisions Act of 1989. In other words, a contract for the sale of land has to be in signed writing. And the argument was enhanced by the fact that in the Cobb case, which you'll recall is the House of Lords commercial type situation case, Lord Scott had said, well, that could well preclude the operation of proprietary estoppel, because proprietary estoppel wasn't an exception set out in Section 2. Now, what His Honour Judge Rayside found was that the existence of the unenforceable agreement did not preclude proprietary estoppel in this context. And to be fair, the exposition of the legal principles in the judgment was a bit limited. What he also, I think, missed was that there was a more detailed exposition of the arguments and principles in the case of Farrer and Miller, Lord Justice Kitchen. Now, that wasn't actually a case where anybody had to decide whether the Section 2 argument was a good one. It was about whether it was arguable enough to be pleaded. So it doesn't actually stand as authority that it's definitely right. But I think that, so Wills and Sauray is, I think, the first case which actually says, no, Section 2 doesn't prevent you from bringing the claim. But in Farrer and Miller, probably the best argument that was put forward is this one, and it must logically be right. Section 2 prevents the agreement from being a valid contract, but it doesn't prevent it being an ingredient in another cause of action. And when you think about it, that must be right, because if it had been the case that the promise had been simply a promise, I'm going to leave this land to you, and then things were done in reliance on that, you've got a clear case of proprietary estoppel. It can't then be right to say that if they've actually said, look, if you do this, then you will inherit this land, there isn't a case for proprietary estoppel. It would be rather perverse if that were right. So I think that Wills and Sauray probably puts to bed the argument that Section 2 prevents proprietary estoppel. But in any event, it was certainly, in my view, a pretty duff argument in any event. The second case, Haberfield and Haberfield. This one I need to tell you a little bit more about the facts on. This was a Court of Appeal decision, again, primarily Lord Justice Lewison. So Frank and Jane, mum and dad, were farming partners from 1975. Daughter Lucy joined the farm in 1983. Traditional insurances, if I can put it that way, that if she worked on the farm, then the business would pass to her when dad couldn't run it anymore, subject to various qualifications about provision for brother and sisters. She worked many years for low pay. And then this is one of the important points. In 2008, Frank and Jane said, well, let's regularize this position. Let's set up an LLP in which you, Lucy, and we are the partners. Your partner with whom you've got 3 children, Stuart, will be an employee. And ultimately, you'll be the owner of most of the farm under this. Now, reading between the lines, they were all awkward characters. And Lucy said no. She was unhappy about Stuart's role as a mere employee. She was unhappy that her sisters would interfere, and therefore she wasn't going to take it up. So they carried on as before. There was a big falling out in 2013. Indeed, Lucy and her sister Sarah had a punch-up in the dairy. And then next thing that happened was that Frank, dad, died. Lucy brought a claim saying she was entitled to an interest in the farm. And at first instance, she was awarded a cash sum of 1.17 million in lieu of any interest in the farm. Now, the reasons that were given for that were, first of all, if you split the farm land from the farmhouse, there was significant tax implications on that. And secondly, Mom was still alive. She was 81 years old. And the court wanted to give her the opportunity to raise the monies to stay at the farm. Now, there was an appeal on a number of different bases, but there were 2 really of note for our purposes. The first one was this: did the refusal of what was, in hindsight, a reasonably sensible offer in 2008 mean that it wasn't then inequitable for Frank and Jane, mum and dad, to resile from their assurances? And secondly, and this ties in with what Sarah's just talked about, should the award be upheld in circumstances where the costs of the unsuccessful defence of the litigation meant that Jane was going to have to sell up and move from the farm? The answer to the first of these was, well, no, the refusal of the offer did not have that effect. And the court looked at it this way, said that the whole idea of proprietary estoppel is that promises should be kept. Now, if Lucy was going to waive her inchoate rights under proprietary estoppel by refusing the offer, then she must have known that she would have had to have known that she had those rights in the first place, and the court felt that she didn't. Thirdly, the offer actually fell slightly short of the expectation that Lucy had. And then finally, the court said, well, when we're dealing with proprietary estoppel, we decide the remedy at the time of trial, but we do that by looking back over the whole course of dealings between the parties, and it will be inappropriate to focus on this one incident. So the answer was that the offer didn't preclude Lucy from bringing her claim. And the second question, which is in relation to costs, should the fact that the unsuccessful mother is going to have to sell up alter the remedy that is given? The answer is, well, no, it shouldn't alter that remedy. And the reason for that, I've put out the quote there, not legitimate for a liability of a cost arising from the unsuccessful defence of a claim in proprietary estoppel to be used as a means of denying or postponing what would otherwise be the claimant's award. And the reason for that is that the expectation that Lucy had was predicated on a harmonious family relationship. And given that Jane had induced that expectation, she couldn't then deny it, then seek to argue that her costs occasioned as a result of denying it were a good reason for denying the appropriate relief to Lucy. So she couldn't make a promise, renege on that promise, and then argue that the costs of reneging on that promise should in effect fall on Lucy. Now, that makes a lot of sense, but it's slightly at odds with some of the other cases that Sarah's talked about a few minutes ago. Now, my third case, a case of guest and guest, yet another farming case, and it's another award of a lump sum. And I just pause there. If you'd asked me 10, 15 years ago, is a lump sum likely to be awarded in proprietary estoppel cases, then I think the answer would probably be no. It was quite unusual. But there is this growing trend to award lump sums and to effect clean breaks between the parties going forward. Now, this was an appeal in relation to the fourth of my categories, in other words, setting the extent of the equity. And there's long been a tension between awards which are based on the value of the promise and awards which are based on the value of the detriment. Now, just to explain that by putting some crude figures on it, you might have a farm that's worth £1 million, and Dad says, one day, son, this farm will be yours. And as a result of that, the son doesn't take another job, which might have earned him another £250,000. And the question is, are you compensating the son for not having taken that job worth £250,000? Or are you compensating for the fact that Dad's broken his promise and not given what he said he would give? And the traditional approach for the courts is to try and duck this point altogether, or answer it in a way that is pretty incomprehensible. But when it came to the Court of Appeal in guest and guest, they couldn't really duck the point. And the decision that they gave there was that the award was to be based primarily on what had been promised. One day this will all be yours, rather than on the detriment. In other words, the shortfall in wages that the son had experienced over the years. And the reason that the court gave for that is that there's a need to focus on the insurance which has been made. Because what we're really doing is looking at what the claimant has lost as a result of an unconscionable failure to honour a promise. And therefore, it would really be wrong to allow the parents, in that case, to break their promise and say, we're not going to give you this farm worth, my figure's £1 million, but we're just going to compensate you for your own shortfall, your own outlay, so to speak. And that wouldn't be the approach, of course, that would be taken in contract. You'd be compensated for loss of bargain. And so that the focus now, I think, is on what is the promise that has been made, rather than what has the person lost by way of detrimental reliance upon that promise. And another point that the Court of Appeal made is that loss of opportunity for somebody who decides to devote their life to farming, for example, is unquantifiable. And therefore, the court said, well, it's fair to take what was promised as a rough proxy for what has actually been lost. I'm not convinced by that point at all, but that's what the Court of Appeal says, and another court's probably more likely to listen to the Court of Appeal than to me on that. Now, we have to note that in Guest, that was a case where it was on the basis of what we call reciprocal performance by the claimant. So in other words, he'd served his time on the farm for very low wages. Many of the cases fall down on this point. So the claimant comes to court having fallen out with his parents after 15, 20 years, rather than having worked hard for 30, 40 years. Now, what happens in those cases? Now, for that, I think we need to go back to Lord Justice Lewis in Haverfield, where he said, looking back from the moment when assurances are repudiated, the nearer the overall outcome comes to the expected reciprocal performance of requested acts in return for the assurance, the stronger will be the case for an award based on or approximating to the expectation interest created by the assurance. This does no more than to recognise party autonomy to decide for themselves what a proportionate award would be. So I think in practice, what this is going to mean is that if you have only if you as the promisee, the son who's received the promise, have only performed half your bargain, so to speak, you've only worked on the farm for half the time that you were expected to, then you're likely to get a scaled back version of what has been promised. And that, I think the court's going to find, will be sufficient to satisfy the equity that's been created by the promise and the part reliance upon that promise. That's all I've got to say. If I can hopefully turn my screen sharing off. And I can't actually. Got it, right. Yes, turn that off. So thank you very much. Thank you.
Thank you, Richard. Sorry, everybody, that we've gone over the allotted time by a slight amount, but I hope that you found those variety of topics useful and that you would join us for part 2 in a couple of weeks. It just leaves me to thank you for attending and on behalf of King's Chambers to thank you all. Before you leave, what I will say, this has been recorded. So if any of your colleagues weren't able to attend, but they want to have a look at the seminar at their convenience, then what we do is we post a link. I think it's on YouTube, but it gets circulated. So please do direct them to that link. What I will do also after the seminar is I will circulate the slides as well in PDF form. So again, keep those for your reference and feel free to disseminate those amongst your colleagues. But thank you very much for attending. We hope to see you soon. Thanks.